They took the views of jurists. And my lord, at page 6, the High Court's opinion is taken. High Court after High Court saying that it is not necessary to have this 3-year rule. That goes on to page 7, page 8. Now, my lord, page 9 is the expansion of judicial academies, so that, my lord, in 2026, this your lordship knows, but I'll just quickly say, at page 10, bottom of the page, almost all the states except a few small-sized states have full-fledged state judicial academies. So, my lord, the time is ripe, actually, at a time when it is right to do training of judges whom you take in after, my lord, the NLUs, they pass on from the NLUs. At this very time, my lord, we are sending them back into 3 years of dedication. Then, my lord, page 11 is the article by the retired director of the National Judicial Academy, suggesting in the middle of that page, para 13, that the 3-year practice requirement may be replaced with a mandatory intensive induction training program, etc. Now, the other aspect is judicial education in collaboration with universities. So, my lord, at the bottom of page 11 is, my lord, the American example of the University of Virginia. But if you turn to page 12, again and again, my lord, repeated recommendations are made that the Judicial Academy should collaborate with universities across the country. Bottom of page 12, my lord, is the French model. Now, my lord, page 13. The suggestion made here is, my lord, experiment.
Basically, you have combined
the suggestions of
the opinion of all the law universities.
Yes, well, but there are some things that are interesting because it was missing in the learned amicus's presentation. So, experimental learning, judges who are taken from day one through legal aid, clerkship and internship-based models, continuous evaluation and accountable mechanisms, holistic and evolving judicial training. At the bottom of page 14, my lord, I give you the status as far as the NLUs are concerned. What did they tell your lordship? Because I think the presentation of the learned amicus may not have been comprehensive. Turn the page, my lord. Page 15, 16. There seems to be very emphatic interventions by the NLUIs and the leading law colleges. My lord, that's at page 15, 16, 17, 18, 19, 20. Right up to, my lord, page 24. No, past that, my lord. 26, Jodhpur. Right across the country, my lord. The NLUIs seem to be telling your lordship that you should not have the 3-year rule. This is, my lord, right up to page... Almost the end, yes. But I want to show your lordship something more. Give me a second. Now, my lord, look at... now, my lord, page 35. This is, my lord, about vacancies. That when the examinations are held for the higher judicial services, there are a significant number of vacancies in the country. So your lordships are having a sort of a problem filling the vacancies for judges. Now, if you turn the page, my lord, page, my lord, 35, 36, top of the page, only 20% of the graduates from NLUI are entering law practice. Apparently, the experience of the national law universities is that if you have the 3-year rule, very few of the graduates from the leading law colleges would be inclined to go for judicial service. 36, the first paragraph, my lord, is a speech by Chief Justice Ramana, as there's one. I find that very few students who graduate from the national law schools are interested in joining litigation.
And page 37, we are trying to point out that there is a conflict of opinion, and then your suggestions are at page 38 and 39.
Yes, one last thing, man. The bench, the judgment of the previous bench was 3 judge. The previous bench is also 3 judge. It reverses the earlier judgment completely. And how was it done, my lord, without a reference to a larger bench? 3 judge reversing 3 judge. Maybe right, maybe wrong, we don't know, my lord, but it reverses it totally without constituting a larger bench.
Do you want to add something more to your suggestions?
Your Lordships, if Your Lordships have my written submissions, Your Lordships, my Lordships, read out for Your Lordships.
Because I want to add one thing plus one point.
Your Lordships, Roman number 6, Your Lordships.
Yes, we have a copy of your suggestions.
Your Lordships. So Roman number 6 till Roman number 9, Your Lordships. So these are the brief suggestions that we have placed on record, Your Lordships. Your Lordships,
The Lordship proposed phased implementation framework that it is respectfully submitted that a phased and time-bound transition mechanism is essential to ensure institutional stability and fairness to aspirants. Transitional cooling period up to 2029. That this Honorable Court may consider prescribing a cooling period till 2029, during which the 3-year requirement is kept in abeyance. Alternative experimental pathways are recognized. Judicial training infrastructure is strengthened. Phase 1 up to 2029, institutional preparation. That during this phase, a post-selection training program may be expanded. Legal aid-based experiential training may be introduced. Law clerkship at the district judiciary level may be institutionalized. Phase 2 from 2029 post-selection legal aid training. That from 2029 onwards, selected candidates may undergo mandatory legal aid-based training, including engagement with legal services authorities, mediation and grassroots justice delivery systems. Phase 3 from 2030 onwards, integration with legal education. That from 2030 onwards, the final year of LLB, BLLB, 3-year or 5-year, may include a structured 1-year internship comprising 6 months at the district court, 6 months at the high court. This would institutionalize early exposure and reduce reliance on post-degree litigation practice. Phase 4 from 2031, pre-selection practice requirement. A pre-selection mandatory practice model may be introduced. Candidates may undergo structured practice prior to selection. The scope of practice may include litigation, drafting, advisory, and legal aid work. Law clerkship model at the lower judiciary. That a nationwide system of law clerkship at the district judiciary level may be introduced. That such clerkship would provide a direct exposure to judicial functioning, strengthen institutional capacity. Serve as an alternative experiential pathway. Alternative framework, if the phase model is not accepted, that without prejudice, a 2-year composite model may be adopted. 1-year post-selection training, that mandatory judicial academy training with structured modules and supervised attachments. 1-year structured mandatory internship integration with legal education. That the final year of LLB, BLLB, 3-year or 5-year may include a structured 1-year internship comprising 6 months at the district court and 6 months at the high courts. Special provisions for persons with disability. That it is respectfully submitted that persons with disability may be required to undergo only 1 year of mandatory practice, preferably post-selection. Such requirement may continue only until accessible judicial infrastructure is fully operational. Alternative pathways such as clerkship and research roles may be recognized. That it is further submitted that reasonable accommodation, accessible physical and digital infrastructure must be ensured as a precondition to enforcing any rigid eligibility requirement.
Lordship, may I submit? Lordship, I appear for. I just have one addition plus before. Plus, public employment laws in the Indian classical dream laws. The only public engagement that is available in legal practice is not this engagement laws at the judicial level laws and the appointment. And therefore will also perpetuate that situation and if take it away by putting in laws a 3-year gap is well something which would impede the entire course of justice and the judicial delivery system, and also Mullad's denial of affirmative action, which is available under the Constitution and your Lordship's plus judgments. The second part only is one, we need to have national exams at one level, state exams at different levels, different dates, and in a gap, which actually again puts a spoke in the wheel, is something also which might need to be addressed while your Lordship is talking.
Lordship, I appear for an intervener, Rahul Bajaj, and we have filed an. I'm sorry.
Yes, please.
Yes. Lordship, the intervention application number is 83490. This is in Bhumika Trust versus Union of India. I will straight away take my lords to the suggestions that we have given while as my lord is deciding the practice eligibility criteria for 3 years. We have given certain suggestions on how the reconciliation between the all India judges and in re-recruitment of visually impaired judgments can be done. I'll straight away take my lord to para 16 of my IA, which is internal page number 8. Do my lords have it?
Yes, you got a Lordship.
I'm sorry, Lordship? Yes, all right. Yes. So, Lordship, we have basically suggested 7 suggestions. One is basically to identify that the lawyer is lawyer with a disability. That is also given in the paper book. The second point that we have made is that in the legal in the panel councils as well as in the legal aid panels that are set up by high courts and district courts, there should be reservation for people with disabilities. Delhi High Court has already done this as part of its legal aid panel that I want to cite as an example. BNC basically takes care of that point. Then I am also requesting my lord to issue directions to set up and have functional accessibility committees in high courts and in district courts so that lawyers with disabilities can get the accessibility support and reasonable accommodations that they may require to discharge their professional obligations.
I guess the judge is speaking.
So sorry. Sorry.
So I'll let you know when they're done.
Yes.
Yes. Lordship, in para E, what we are requesting is Bar Council of India to set up an accessibility fund so that lawyers with disabilities can be provided necessary support in terms of sign language for deaf and hard of hearing, also the quieter rooms for invisible disabilities, and human support for persons with other disabilities. Assistive technologies, my lordship, is not covered within this, but that is something I would like to submit additionally. We are also requesting that regular sensitization of both lawyers, court staff and judges be conducted on an annual basis so that they are more sensitive to persons with disabilities and they understand the issues being faced by persons with disabilities. In Supreme Court, we are recommending that this can be done through SCIORA as well as SCPA. And the Lordship, the other point that we have made is that the PSU and law firm experience has may be considered while calculating the 3 years requirement for lawyers with disabilities. The last point that I want to make, Lordship, is basically Section 21 of Rights of Persons with Disabilities Act 2016 requires all establishments, and my lord, that definition is given in Section 2I and basically 2E and 2V. 2I defines establishment, where we are saying all law offices, which will include law firms or such other establishments as are notified within RPWD Act, to formulate and notify their equal opportunity policy and register it in line with the Act with the Chief Commissioner or the State Commissioner as the case would be. If my lord would be pleased to allow the IA and take the suggestions on it.
Noted very vital issue you are raising. But it's slightly different than the review application which we are considering. So maybe that we will deal with these issues independently and separately.
Okay.
Your Lordship, if I may just add, Your Lordship's two aspects. The suggestions which have come are very good. We have on our side, Your Lordships, we have examined all the rules of various high courts. And what we find is that most rules have a hybrid of situations where there is an entry-level practice that is required and then the training is required. We have given in our suggestions, Your Lordships, two high courts especially, Assam High Court as well as Punjab and Haryana High Court, where they have a staggered training period which is inducted, Your Lordships, and depending on the number of years of experience you have, that is the proportionate training that you will receive post-induction, Your Lordships. And this is specifically suggested in view of the fact that, Your Lordships, in all other employment spheres, especially in civil services, Your Lordships, all the people go and take those exams, Your Lordships, and in the judiciary, only the people who do not succeed in civil services, they come. It is never their first choice, Your Lordships. And secondly, for women, especially, Your Lordships, by the time 3 years finish, their families do not want them to take any professional jobs, Your Lordships. So this restriction, Your Lordships, is actually taking away both the merit of the service and the dignity of the service as well, Your Lordships. And it actually amounts to an Article 14 violation in comparison to other services, Your Lordships. So we have suggested, and we've given it to the learned abacus also, Your Lordships, the staggered training program to remove the bottleneck of access. Let us allow us to take examinations, and depending on how much ever experience we have, that much training will be given. And Your Lordships will see that the Assam model has practical and adoptable model, Your Lordships. The candidates with prior practice undergo shorter training, whereas candidates without such experience undergo extended structured training. And in that, they have rotational court attachment, they have institutional training, and they have supervised adjudication. So this is a model which has already been formulated. In Punjab, Your Lordships, they undergo an entire 1-year training as soon as they are inducted. Same as civil services, Your Lordships. So these are the 2-3 points that we have suggested, and a detailed, Your Lordships, roadmap. And my learned friend's suggestion that there should be a judicial academy looking at it centralized, in a way that might not be workable, Your Lordships, because all the high courts have peculiar language and cultural and social aspects, Your Lordships. So it probably will need to be worked out at the high court level is my suggestion to Your Lordships. Grateful, Your Lordships.
May I just make 2-3 questions? May I just be permitted to make 2-3?
Your Lordships, may I please be allowed? Your Lordships, I filed an intervening application back in March with regards to women with disability and the 3-year practice. Your Lordships, I would just try to raise a few parameters with regards to concern where accessibility, safety, and societal pressure is concerned, Your Lordships. Your Lordships, please be considered that where women with disability are concerned, their practice is largely dependent upon how accessible the infrastructure is and how their families pertain to their safety concerns and the societal pressure that they have, which already hinders their professional mobility under Article 19, Your Lordships. Your Lordships, please be considered that it's a compounding disadvantage and an intersectionality between gender-based bias and disability-based concerns, Your Lordships. Please be considered that it's humbly prayed, Your Lordships, that before any decision is taken, this please be considered, Your Lordships.
My Lord, is almost same that Mr. Bajaj, I think.
I didn't get that.
My Lord,
We'll consider that.
My Lord, I am appearing for High Court of Karnataka. My Lord, we have filed applications.
Not in view of high court at this age.
No, we are in difficult balance.
We are going to file an application, some urgent application is filed, seeking permission to withdraw the notification and issue a fresh notification. My Lords, may kindly have a look at our application. We had issued a notification for its inviting application. Thereafter, Government of Karnataka has come out with an order saying that we should have internal reservations. Therefore, once a fresh notification requires to be issued, just as a measure of abundant caution, this application is filed, seeking permission to withdraw the notification issued earlier.
All right, I allowed the High Court is permitted to withdraw the advertisement and issue a press advertisement strictly in accordance with the law.
As I moved an application on behalf of law officers working in PSU. My lords, we are seeking parity with respect to the exception carved out to law clerks. My lords, the law officers working in PSU as well are engaged with respect to work.
Law clerks are working with they are integral part of
My lords, the reason we are seeking is this, that I'm preparing notes, the work profile, my lords, of a law officer in PSU would be, we have a fixed client. I'm preparing notes, I go to the court, brief the seniors.
With respect to this review application at all.
No, my lords.
It's not with respect to this review application.
No, my lords, I moved an application separately and I've served a copy on the learned amicus as well.
It will not issue with reference to the review application.
My lords, we'll take it.
The review are confined only to the 3 years.
3 years.
Condition. So the review are also being reviewed.
No, my lord, I am for a high court, my lord. I have what your lordship said, my lord, so I was, my lord, not
Agree that
May I be permitted, your lordship, just 2 submissions, your lordship, before London amicus start with your lordship, just 2 submissions, if lordship permit me. I have filed 2 IAs before this honorable court on this premise that my higher qualification is an impediment. So your lordship has already considered, High Court has not considered our... Your lordship, no, I am here in review, your lordship.
We have been telling you regularly.
Yes, your lordship.
The High Court. We have told you enough times.
High Court has not considered our case. They said that you just try your lordship, I'm just on different point.
Judicial side go before the
I am on purely on 3 years issue so far as review party is concerned. Dropping that issue, I'm not touching it at all. Genesis of the entire case is para 56, your lordship, of the judgment dated 30th of May 2025. And this is born out of Article 233(2) and 272(b) of the Constitution of India. Reason being, the Law Commission's reports have considered, primarily in the Shetty Commission report, that 7 years and 10 years practice at bar is for the higher judicial examinations and the High Court level for 10 years as a experience as a lawyer or the legal practice, your lordship. So that is the genesis that a civil judge or at the lowest rank, there must be some experience. And this has born out of para number 56 of the impediment judgment, your lordship. This is under review before the honorable court, and this is the impediment which has come up now. And on that parameters, your lordship, 3 years criteria has been put in it. So just 2 submissions to that effect, your lordship. Just wanted to give this before this honorable court. This is on a France model, on a Denmark model, your lordship. And 2 or 3 suggestions which have also, just going to give you lordship. In France, your lordship, it is judges are selected through a competitive examination and then undergo 31 months of professional training before appointment. So my submission is that extensively this has to be. And second one is, lordship, on Denmark basis, law graduates can be recruited as deputy judges directly after school or after gaining some experience. So this is not there in our country, your lordship. Your lordship, just 2-3 lines I'm just putting in and then closing it. They assist judges undergo 3 years of training and must pass a final examination before becoming permanent judges. This model may be useful in India as it can improve judicial strength, reduce case pendency, and provide financial security to young law graduates. So one step ahead of it, that instead of many other options, one more options may be given so that aspirants can directly be absorbed and deputy judges, they can assist the civil judges, and thereafter final examination has to be there so that they are fully equipped. Your lordship, at the lowest level, it is the best acumen we need. Reason being, the judgment travel up to apex court, your lordship. That's why the training at the lowest level, as well as in the law schools, and also, your lordship, for the training in the judicial academy is a must to get it. I'm so grateful, lordship, always.
My lord, now I am not treating this as adversarial at all. So I'll just, my lord, since my lord.
Yes. One is supposed in 3 years to be returned.
Yes.
And how to document, how to implement.
Yes, so my lord, in fact, your lordship might recall, on the very first day when your lordship took it up, I had given a note of suggestions. One of my suggestions was that I can understand today they might be going through some difficulties. Your lordship may have it as a staggered basis. For this year, for instance, in 26, if you may not need any experience, 27 1 year, 28 2 years, and then finally go up to 3 years. Because, my lord, in my respectful submission, the judgment of your lordships of May 25 has considered this aspect in very great detail. You know, it's not as if it's just something that your lordship and the high courts, which are the institutional courts, which are more conversant with this than any of us, and your lordships have that experience about how the judiciary must function, their views must be taken into account, and overwhelmingly the high court said,
High courts we know very well.
that's right,
The
correct.
moment we give a judgment, they will never take
No,
it.
I'm talking about pre-judgment. I'm talking not after that. So your lordship may not take into account what they're saying after 25. I'm saying what led your lordships to the 25. Yes, so that's what I'm saying. They will not at all influence. Now, my lord, your lordship will also see that till 1993 judgment of the Supreme Court, which said 3 years experience is required, even prior to that, always, my lord, the judiciary had people with experience coming in, whether 2 years or 3 years. In fact, pre-independence onwards. 93 judgment said 3 years. Then, my lord, 2002 changed it to no experience required. So only for that limited period, my lord, we've had an experience of, let us say, my lord, 10, 12 years, where there was people with no experience, and the High Court found that it was not good enough to function as a judge. Now, my lord, let us look at what some High Courts are saying about experience. Problem is that if Assam says, if you have 3 years experience, you will undergo less training. Now that 3 years experience is not actual experience in court. The person may get enrolled today, sit at home. I'm not saying it will happen in every case.
No, this is the only thing happened.
Yes.
That they will get enrolled.
Sit at home and prepare for 3 years.
Lawyer will issue a certificate.
That's it. Yeah, correct.
You don't have any
In fact, there's no certificate required. Certificate is now required after lordship judgment. So earlier there was no certificate required. All you have to say is from the date on which I enrolled with the provisional enrollment with the Bar Council, I can sit at home, I can prepare for the examination, I did not go to court, and as soon as my 3 years been, and if I qualify, and I can then say, I have 3 years experience as a lawyer, so please in fact cut down my training further. But these are the kind of issues that your lordships are faced with. No, but I do believe, my lord, that for certain categories, if not a relaxation in the eligibility can be 3 years. But, my lord, for suitable, for instance, my lord, relaxation in marks for, my lord, persons with disabilities is a very valuable suggestion. Clerkships, my lord, for them and for women as well as, my lord, judicial clerkships and preferences in that. All that, my lord, must follow.